on child sexual abuse material and exceptions referred to in Article 14, para 4. We would like to seize the opportunity to explain again why it is of critical importance that we have these exceptions. Under our national law, children may, as of the age of 14 and above, have sexual intercourse. Many countries have similar national legislation. Our national understanding is that children above the age of 14 have a right to develop sexual relationships. Children at this age may choose to have a sexual relationship with a person that is, for example, 19 years, therefore an adult. That children might produce pictures in the course of sexual engagement and share them with each other. Pictures produced as part of a legal and voluntary relationship should not be criminalized. If we do not have these exceptions, we would be obliged to criminalize children for producing pictures of their sexual engagement, although such engagement would be legal.
The exceptions in Article 14 are bare minimum requirements to avoid the over-criminalization of certain legitimate conduct involving children. There is absolutely no way for the EU and its member states to be able to join a convention by which they would have to criminalize behaviors which are considered as perfectly legitimate in our countries. The protection of children from over-criminalization is an objective which is well recognized also by UN bodies.
Article 14.4 would criminalize the consensual conduct between similarly aged children, contrary to the guidance of the UN Committee on the Rights of the Child. Article 14.2 risks criminalizing material with evidentiary, scientific, or artistic value and puts at risk the work of human rights organizations that investigates children's human rights abuses.
Current formulation of Article 14.3 could limit criminalization of child sexual exploitation online to content depicting a real child. Such formulation may exclude animations, cartoons, or other visual representations of child sexual exploitation. The present formulation would defeat the very purpose sought in elaboration of the Convention and inclusion of Article 14 in the Convention, since it would create exceptions. In fighting this crime, we should also take into account that artificial intelligence is increasingly misused by criminals, including for child sexual exploitation. There is no right to engage in the child sexual exploitation or to normalize such conduct. While we could be flexible on having provisions excluding criminalization of children under domestic laws, we see merits in having a clause emphasizing the discretion of states for establishing corrective or rehabilitative measures. This is important. This way, we could ensure that our children are protected from harmful behavior, which might lead to other victimization by criminals too. Nonetheless, we could not accept subparagraph B, as it runs counter to our domestic laws.